Hi, I'm Bill Hodges, and we're about to tape a Sun City Center Community Association board meeting. Now, this meeting will be quite long, so the potential is that it will be more than one part. So when you watch it, look and see whether it's a part 2 or not. This will be designated at the beginning of each. It could even go into part 3. So if you would, please sit back and enjoy. This is a production of Hodges Videos. It is not a production of the CA board, nor have they any opportunity to edit any materials. This is a gavel-to-gavel production. Any place that I've had to stop the tape, you'll see that, and we'll make a note of it. But all of the comments will be on one of the sections of this tape. Enjoy, and be a part of the Sun City Community Association, because being a part gives us good government and a good association. Enjoy.
Okay, see, we've got a red light on the machine, so we can continue with the business meeting here today. The next issue to discuss is the tennis courts, and Director LeBlanc.
Mr. President, whereas the Competitive Tennis Club is an approved CA club and has a right to use the CA tennis courts, and whereas the Competitive Tennis Club by its very nature plays competitive tennis against tennis teams that are not CA members, I move that the Competitive Tennis Club be permitted to use the CA tennis courts in competition against non-CA members as outlined in the course use agreement dated March 2nd, 2007, and signed by the presidents of the Tennis Association, Competitive Tennis Association, and Community Association.
Is there a second to the motion?
Second.
Okay, second to the motion. Director LeBlanc, since you're the maker of the motion, would you like to start the discussion?
Well, I really would. Okay, that's fine. I feel like I have been discussing nothing but this for about 2 years now. But here we go. It would seem that this is a problem that will not go away. Since I am the mean-spirited CLD that allowed the competitive tennis to come into existence, I would like to explain why. The would-be CTC, along with the then president of the TA, came to see myself and Paul Wheat, and then the then president Community Association. I am the only surviving member of that foursome in any power at this point. I have firsthand knowledge of what happened. We listened, told them to try to work this out for themselves. They tried and talked, and then came up with a compromise position. Instead of 9 o'clock slots on Wednesday, the CTC would take 10:30. An agreement was signed between the president, the TA president, and the CTC president, and the president of the Community Association. This, however, did not bring peace and courteous treatment to the CTC members using the Community Association courts. There was constant name-calling and harassment by certain members of the TA who were determined this club not exist. And remember, this was using 10:30 court times, not 9 o'clock as they are currently talking about. These activities resulted in the entire board of the CTC resigning. For 7 years, approximately, the CTC had tried to become a part of the TA, and for 7 years it had been turned down. That is why they did what was properly called for by our policy. In the manual, the policy manual for the CA, under organization, it says that a significant function of the Sun City Center Community Association is to provide and manage recreational facilities for the benefit of its members. Appropriate clubs may be formed to organize members desiring to use these facilities and to participate in such activities. The CA president shall annually appoint a CA director to administer and oversee club affairs and to represent the CA board in all matters pertaining to clubs. He or she shall be designated the club liaison director. Clubs desiring to utilize the CA facilities must officially affiliate with the CA. You have to become a club under our umbrella. To do so, I'm not going to go into all of the steps. Those of you who have come know you get a packet from us which tells you how you do your bylaws and what they are supposed to say, etc. But the initial club membership of 10 is required. A lesser number can even be approved by the CLD. Clubs must become an affiliate of the CA, as I have said, and then be approved officially by the CLD. Clubs that wish to open their activities to participants outside of those permitted may make written application to the CLD for a waiver. When such a waiver is granted, the club may be subject to fees or to an additional cost or participating members. They may be. Okay, the president has the authority to speak for the board, and the CLD has the right to make club decisions on behalf of the board. The BOD of the CA was kept apprised of every action taken during the establishment of the CTC. They heaved a heavy sigh when at last the agreements had been reached. I guess as a rookie in this CLD slot, I did not think it necessary to take an official vote of the Board of Directors, and neither did they ask for one. In accordance with the Board of Directors, I turn down or approve all club business. I did not think this was different, nor did the TA request a board meeting at that point. When 42 members of the CA who pay over $10,000 a year for membership dues in the CA approach with a legitimate request, you listen. It is not the fault of the CTC that the laws of the A lot and B lot competition requires that you have a 9 o'clock court time. Without this, there would be no one in Hillsborough County for which the CTC to compete. Does it make sense that this club would have to travel to these other courts, bring the refreshments so that they could serve as the host company, that every time that they go out to play on these other courts, they have to take advantage of those? So this club uses only 3 of our 50 court times at 9 o'clock, talking about Wednesday. This is not an unreasonable request. TA members can still use the additional 7 courts or play at 7:30 or 10:30. And what has been the answer to some of the vocal members of the TA? Relentless harassment and even profanity to CTC players and guests. This was the cause of an entire executive board of the CTC to resign. It has reorganized and there is a new board. The TA is a club of which we can all be proud. It has been in existence for a long time. And this loud and vocal element is kind of a surprise. I have had letters of support from TA members as well as letters of support from the CTC members. Every night when I go home, my otherwise email that has about 5 letters, and that's from my family. Now I find that I have about 25 things on. Some of them are not very nice, and some of them are very supportive. And you know, you take the good with the bad. That's just how it goes. And so the TA, the club itself, the big part of the club has been wonderful. Both the past president and this president, they are duly elected by the Tennis Association to represent them. They have done it. They have, the people who are on the boards have been elected by the Tennis Association. And I, as the CLD, listen to the presidents of clubs. I bring in both of them, so I hear both sides. I want you all to know I do not play tennis. I have been down to the courts often enough in the last year or so, but I don't play tennis. I have no partiality toward one or the other. I just feel very strongly that these 42 people should have the use of 3 of our 9 o'clock slots. And I ask that our board honors the contracts to provide the CTC with the right to use these 3 9 o'clock courts. Please give your support to this issue.
Okay, thank you. Director LeBlanc, does any
May I
other
have a
director
word?
have anything to say?
Yes, I'd like to have something to say. I always have something to say. Can you hear me? As an elected director, it is my duty to follow our governing documents. It is my belief that these documents are either made to be followed or changed in their proper manner. In 2007, a legal vote of the TA membership was overturned by 2 directors. A CTC club was formed by 2 directors, allowing non-members use of our facilities. The legal claim for starting the club has been stated as board policy. I'd like to remind the board that articles and bylaws trump board policy. In Article 2, it states that we, all of us up here, the board, shall serve the residents and manage recreational facilities. Bylaw 2 reads that the board, all of us, shall have full power and authority to manage the affairs of the association subject to articles and bylaws. It also states that a majority vote of the entire board is required in non-member use of association facilities. Bylaw 2 states that the board may establish policies under which non-members may use facilities on a space available basis. The tennis courts are one of our facilities. Board policy states that usage by non-members is expressly denied, and so is the use of CA facilities for tournaments, exhibits, and other functions which include participation by persons outside CA membership. Use of facilities for any of the above require an application to and approval by the CA board. That's all of us. I am aware that other clubs have outside member play, but they are not the ones before us today. Apparently, they have not had club membership voting overturned, nor have had their space available threatened. My decision today is not based on male versus female, who said what, hearsay, club versus club, or member versus board member. It is simply based on running a business and following the rules. In an email dated February 24th, the president of the CTC declares to her membership that 3 directors have confirmed they are a legal club and the CA board will be taking care of the matter. She also states that they will keep them informed and action will be taken before the TA membership meeting of March 18th. Well, folks, here it is, March 11th. And I just learned of the CTC motion on the 4th. Today's motion is nothing more than a cover-up of the mistakes that were made 2 years ago, and I refuse to be a part of it.
Okay. Any other board members have any discussions?
Yes, please, sir. What we're doing here today is crossing some T's and dotting some I's. What happened 2 years ago was not, it didn't, if it did not, and I say if it did not, I'm not convinced it didn't follow the exact format that the bylaws called for. We are going to rectify that today by approving this this motion. In fact, the Competitive Tennis Club has been in existence for 2 years. It's recognized not only by this board, but apparently by the Tennis Association, because they've been working with them for that long a period of time. And frankly, I'm kind of confused about what all this fuss is about. I was one of the board members on, I've been here long enough to know and support what Anne Marie is saying, that we knew about it at the time the club was formed. If we didn't take an official vote, we certainly had the opportunity to object to it, and the fact that no director objected to it, no director brought a motion to kill it, indicates that it had 100% support, at least in my mind. So it had tacit support if it didn't have actual support. So as I say, if we're not following strictly the bylaws, we certainly gave it our tacit support. I guess I'm troubled by this whole notion. I thought we all learned in kindergarten that we had to share. You know, that was kind of one of the first rules. And it seems to me we have two clubs, a limited number of facilities or courts, and we simply have to try to work out an agreement. Apparently, the two presidents of the various clubs, or the two clubs, have got together and come to what I think is a fair and reasonable compromise. I'm not clear on how many members of the Tennis Association are opposed to this. There's certainly some vocal ones here today, and I appreciate your coming. But we have an obligation as board members, in fact, a fiduciary responsibility to make sure that we hear not just from the majority on an opinion, but that we respect the rights of the minorities. That's probably one of the most significant things we do here. We cannot discriminate against people because their views might be different from ours. I have no interest in setting court times, and I'm happy that the presidents and the boards of these various associations have been able to come to some kind of an agreement. It's true that there is a space available clause under our bylaws, and Ann is correct when she says that policy doesn't trump bylaws. However, the interpretation of that space available clause is up to this board of directors. And from my perspective, the court time and this home and away concept doesn't impact on the available court time at all. It's really a wash. Plus, there are plenty of apparently courts available at 7:30 and at 10:30 for play. And I don't see what the fuss is about. Although I appreciate there is strong feelings on both sides of this issue. The lawn bowlers and other groups, softball is another example, I guess, do this home and away thing, and they seem to have worked it out. I don't think that the competitive tennis group is asking for too much in terms of numbers. It looks like they're asking for for less than they'd be entitled to on a percentage basis. So again, I think that we should go along with their request, but again, it's the community association owns these tennis courts, and we have to look out as board members, and our responsibilities here for all of the residents, not just one club as opposed to another. We have two tennis clubs, and we've had two tennis clubs now for 2 years, and it's about time we all learn to get along and play nice. Thank you.
Okay, any other directors have anything to say? Yes, sir. Mr. Nelson.
Thank you, Mr. President. I'll try. That's too hot. Your hand is very hot. Good morning, ladies and gentlemen. I sit here and I listen to what is being discussed, and I read the motion that we're talking about here. It's about 100 words. It covers a number of lines, but, you know, and it always kind of amuses me how sometimes, from a political standpoint, that we write a motion that is so really kind of very confusing to most people. I mean, in essence, what it comes down to, when it's stripped down, is when you take out the whereases, 2 of them, and you take out the 10 CAs that is mentioned over and over again, what we're doing right now is we are being asked to vote to validate an action that occurred 2 years ago. And this was before my time, and I know Patrick says we have given it tacit approval. And I don't know about that. I don't know what a tacit approval is. I do know that by bylaws, there are certain things that you have to follow. And every time I know, in the 2 months that I've been on the board, when I step out of line and I don't follow a bylaw, I get my fingers tramped on. Now, I'm not sure that I could simply say, 2 years ago, I was new, and I really didn't know the rules. And I'm not sure that that is something that is strong enough to stand up in any kind of a court, especially in a membership of 11,000 people. I'm very disappointed in that. I'm also was very disappointed in the fact of how this came up. We never talked about this amendment in our board at all. This suddenly showed up yesterday in our little books that we get as an amendment. There was not one discussion held on this this week, this amendment that we talked about. We talked about all the other amendments, but we really never talked about that. That bothers me a little bit too, because I don't feel like I'm really comfortable with the way it came across. In my estimation, the 2007 agreement was not a solution. And you know why I say that? We're here. We're here. We're having this discussion all over again. It just amazes me that we are going to vote on, asked to vote on something that we should have ratified two years ago, that we didn't ratify, and now we're being asked to vote on it, and it hasn't worked. I guess I'm just a little bit confused about why we are trying to do this right now. I consider it to be actually CA interference. I think the clubs, both the clubs, can sit down and can work this out themselves. And I really wish they would. And I think that they have the opportunity. We have shown that our solution doesn't really work to form two clubs. And I wish everyone could get down and just try to work it out amongst themselves. We have a meeting coming up on the 18th of March, as I believe. There's a referendum that's coming up. And the TA and the CTC and everyone gets to vote. Why do we want to take this away from them now? We vote, we take this away from them now, then what's the point? There isn't any. So I would simply ask this. I don't care who uses the courts. I don't care about the number of hours. I don't care about anything that I'm given 160 hours that we were supposed to use the court, and it's only being used 10 minutes or 10 hours a day, etc. I don't care about that. What I really do care about is our community. And I think that we ought to sit down and be able to work this out amongst themselves at the tennis level and not have the CA sit down, come in, become the judge, become the jury, and become the executioner for these clubs. Thank you.
All right, thank you very much. Any other directors have anything to say? Director Shing?
Yes, Mr. President. Ann, when she was reading the bylaws before, used the word vote. I had the bylaw in front of me, and the word vote is not in there. The bylaw 2 states, the majority of the board shall constitute a quorum for transaction of business at a regular or special meeting, okay? Except that approval by a majority of the entire board shall be required for the following matters. Now, I don't see the word vote in there. It does have the word approval. This item was discussed by Anne Marie in front of the board at our business meetings. We were briefed on this. I approved the actions of the then President Wheat and CLD LeBlanc. So they did have approval. Nobody in that board raised any questions. So I don't know where or who's decided all of a sudden we have to take a vote.
I would just like-
We have laws were voted on by 11,000 people to interpret these laws and to enforce these laws, not to change them to suit our particular issue at hand. So the approval, as I saw it back then in 2007, and I've been here for 5 years, was that it was all right for President Wheat and CLD LeBlanc to do this approval. Now, there are those that say, well, we should put this back on the Tennis Association to do it. We've been elected by 11,000 people to enforce other provisions. Use of facilities by the association, this is a bylaw. The board may establish policy under which non-members may use association facilities. And it's kind of nice when the decisions get a little tough to expect you people to do it, but that's why we get paid the big buck, to make the decision. And I think a decision will be made today. So I'm not willing to pawn off the hard decisions to you. I think they should be made by the 9 members of this board.
Now, Director Cross, did you have something to say?
Yes, I do. I'd like to know and I'm very stupid, you know, and I can't understand how a approval by the board can go on record without some sort of written form. You mean to tell me if you went to court, you would say that I voted for it, but you have no record to prove it? Wouldn't that be just hearsay? You have to have a record of a vote, or in other words, you have to have some kind of a record that an approval was done.
Yeah.
Otherwise, we could all sit here and say, I did that. It's ridiculous.
Okay, point well taken. Any other directors have any comments?
Mr. President,
Yes.
I'm a little confused by all of this. And I think we need further enlightenment. Also, the Tennis Association has a meeting coming up on the 18th. Therefore, Mr. President, I would like to move that we table this motion until the next meeting.
I second the motion.
Wait a minute. We already have a motion on the table, so I guess we can, some parliamentary guidance here. Vote on the second motion?
On the table.
Okay, the vote on the table is to propose to postpone a vote on the current motion that's in process. Yes?
They want to table it to a specific meeting in the future, or to table it to kill it.
Okay.
I move to table it till the next meeting of the board. Next regularly scheduled meeting of the
Board meeting, okay? Second to that motion?
I second the motion.
All right. Those all in favor of the motion to suspend the current motion until the next board meeting?
Mr. Chairman,
Yes,
make a roll
Mr.
call, please.
Okay. Is there any discussion on this?
There's no discussion on it.
Okay. Let's have a roll call vote.
Director Black,
Aye.
Director Alderman,
Nay.
Director Cross,
Aye.
Director LeBlanc,
Nay.
Director Shames,
No.
Director Griffin,
No.
Director Nelson,
Yay.
Director Long.
No.
Motion fails. All right. So does any other director have any comments on the current motion? Any further comments?
I have a comment. Doesn't one of our bylaws require that if 3 board members want to request a meeting, that they have that right? Special meeting?
Yeah.
Yeah.
Oh, well, it's a done deed, you know?
So what does that have to do with things? Okay, so now, I presume that because we have the audience here, that a few of you have some things to say. So, yes, Paul. Okay, all right. So we have some things to say. Because we're videotaping this today, we ask that you use the microphones on each side so that they can swing to get a picture of your face and not the back of your head when you speak to the microphone. So we ask that if you have comments, that you limit them to 2 to 3 minutes, and let's go ahead. Okay? Paul? Sounds like it's on.
It's on, Paul.
No.
Okay? Okay, I'll try to keep it within the time, but since my name was mentioned several times, there's several things of clarification.
I didn't mention your name.
Yeah, my name is Paul Wheat. The 2211 Westminster Manor Lane, and I am a member in good standing. Also, ex-president of the association. Article 3, Article of Corporation 13, excuse me. The Board of Directors shall set policy, doesn't say may, it says shall set policy, in parentheses, as may be authorized by the corporate bylaws of the corporation. Goes without saying. The Board of Directors did set policy. That policy was in effect 2007, and that policy was approved by the board. Therefore, the approval authority of both the CLD and myself is completely legal. The board wants to rectify something, that's fine, they can do it. I stand by that decision, and I'll stand before anybody on that decision. At that point in time, I did what was right, and in good faith. Now, let me go down. I happen to agree with Anne Marie 100% on her recollection, right down the line, with what as it took place. The board is supposed to manage through policy, and that's what they do. The president operates, and the president appointed a CLD. Anne Marie had the authority to do what she did back then. I would like to ask all these people who are talking about non-member use of facilities, how many of you realize the tie-in of non-member use of facilities is with our 501c3 status? And I think I've got news for you. Have you read the original application?
I haven't seen anything.
I would
sure
suggest
they
you
all
read-
have.
I would suggest you read the original application,
Yeah, well,
because in the original application, it actually states one of the reasons for gaining our 501c3 is that we do open our facilities for other than CA members.
Yes, and I mentioned that at our briefing on Monday, and I was told that that was not true.
I'm sorry.
Then you need to speak to
I'm
them.
sorry, I am telling you from a position of knowledge because I have it in my possession and I read it. I also was involved in the IRS when they reviewed it. When our articles were restated erroneously in 1997, they took that out of the article of incorporation to prove that we weren't a 501c3. That's one of the reasons. When the board reinstated it, they put it back in, and the IRS has agreed as of our last contact with our restatement of those articles of incorporation, we are a 501c3 until they notify us otherwise. We came close to losing it because that was taken out.
Yes.
I hope everybody realizes the impact of this. That's why the board established policy. That's why the board has discretion to use the board's best knowledge at the time to meet the requirements. In fact, one of the reasons, 3 reasons for a 501c3 is that we provide relief to the elderly. As explained in our original application, we do that because we allow our members to enjoy the friendship in the surrounding communities. That's a lit verbatim. Okay?
Okay.
Now, surrounding communities.
Please wrap up your
Okay,
comments.
I will. I just want everybody to realize that what we are doing here could have drastic impact. I think the board better be careful. What the board wants to do with the new hours of request, that's their business. But as far as what happened in 2007, it was legal, it was perfectly down the line, and I think it was in keeping with the spirit of keeping our 501c3. Thank you.
Okay, thanks.
May I make a comment on that?
We're not here to debate the audience. We're here to receive information from them, and then we'll go back to the directors and we can make additional comments. So, okay, so over here.
I'm Nancy Williams. I'm a Community Association member. Can you hear me?
Just a minute. Let Mr. Brown get over there to look at the microphone.
I'm Nancy Williams. Again?
There you go.
I'm Nancy Williams. I'm a Community Association member. I'm a Tennis Association member. And I'm a competitive tennis club member, CTC, and I happen to be also the president. So it's nice to meet all of you, those that I have not met before on board. It's nice to meet with you. It's nice to have this discussion. One of our competitive tennis club teams are traveling, and they're in Carrollwood this morning. But for those of you that are members of the competitive tennis club, would you just stand so that the board members can see who you are? There are 42 people that are members of the competitive tennis club. We are all tennis association members. We are all community association members. And we thank you very much for forming a club for us. I want to tell you that we enjoy being ambassadors for Sun City Center. When we have traveled across Hillsborough County, we compete with about 20 other clubs in the greater Hillsborough County. And for the last 2 years, we have done all the traveling. We have not been able to have home courts on Wednesday. Today is Wednesday. One of our clubs is traveling to Carrollwood. But when we were given temporary ability to come and have home courts, we had hoped that we could be able to share with the other people from the Tennis Association that, yes, we can all get along, and we can bring folks from all over Hillsborough to come see the beautiful 10 courts that we have. And indeed, they've been very impressed by what they've seen, and we've enjoyed being able to have the play here at home. And for them to really, in the next couple of years, for some of them, they really considered Sun City as a place that they'd like to be. We have wonderful facilities in all the venues here. I want to speak to a couple of you on the board that I heard that were rather confused, and I would hope that you were not. I have a copy of the approval that Mr. Wheat and Jack Betos and the then president of CTC did. It was approval, and it was in writing, and it was for the 10:30 on Wednesday and for the 9 o'clock on Saturday. Anyone who would like to have a copy, I'd be glad to make that available to you. It is on record. You should have it in your records. We have it in ours. The change is what, if some of you were listening to Anne Marie, we can't play at home on Wednesday without 3 courts at 9 o'clock. It's the only league we can play with. If we don't have the 3 courts on Wednesdays, we cannot play. That's why the Tennis Association Board granted that to us. That is a change to the 2007 approval. That's why we end up being here with all of you, and I would welcome that the entire board would better understand why that is. It is a necessary thing for us to be able to have competitive tennis as well as recreational tennis. I am very surprised that a director would use my personal email to speak her case. My personal email to my personal members is our business. And if you had a question about it, you should have asked me and not made it as a public matter of business this morning. I also want to speak to a petition that was circulated on the tennis courts by our opponents, the petition to have a special meeting. That petition goes against the rules of your own community association.
Can you please wrap up your comments here in the next second?
According to your rules and regulations that you have under your Article 15 of your own bylaws, in the case of petition, the issue must be limited to purposes of the association. Solicitation of signatures inside buildings shall be in the atrium only, not any clubs, rooms, or inside the community hall or outside on association property, but only where it will not interfere with any member's rights. Clearly, the petitions that were taken up in 2007 and the petition that was taken up most recently for a special meeting on the 18th is against the rules of the community association. It's against members' rights to go onto the courts or hang out around the courts and ask people to sign a petition. And I thank you for this.
Okay, thank you. Any other comments, Mr. Messick?
Mr. President and the Board of Directors, thank you for allowing me to speak in front of you. And before I start my presentation, I'd like to make a few comments about what Anne Marie LeBlanc had said. Hold this one, I'm gonna put my glasses on.
That might count.
Factor of living here.
Yeah, welcome to Sun City.
2007, the TA made a motion, but the tennis association had no idea what was going on. That was a clandestine operation, and nobody knew what was happening during that period of time. Nobody. The second thing is the harassment on the tennis courts. I don't know where that came from at 10:30. Nobody's ever harassed anybody at 10:30 on the tennis courts. Okay. And for Mr. Weed, if you look at the 501c3 under sports, only does it cover sports that are international and national. I looked it up. Okay, every club is required to have bylaws, rules and regulations. Even the CA board has them. These bylaws are required because they are the foundation from which the clubs and associations base their existence. They should not be violated or be subjected to arbitration. But what happens when they are violated? Then the whole process at both the club and CA levels tend to fall apart and eventually fail. This is what's happening right now. Just an example of different perspectives, my letter to the editor dated 2/18/09, I stated that the TA bylaws were being violated and the violation was being supported by the CA. In response to my letter, the CA president responded with, quote, "The problem only revolves around 10 hours of playing time. Where was the concern that the bylaws were violated? It didn't seem to matter." The process. A referendum was ordered on by TA members in 2007 and passed with an overwhelming majority. This referendum is still in place, but it has been totally ignored by the present TA and the CA boards. Due to this violation, the TA board was once again delivered another petition for a referendum on 2/18/09. At their meeting of 2/20/09, they blatantly disregarded the petition, signed a new agreement, and sent it forward to the CA. That petition should have stopped any action until a vote of the membership occurred. The statement was made at that time by the TA board, quote, that a membership vote means nothing because the CLD will override it. Where did the democratic process go? I don't know. If the voted majority means nothing, then we are bordering on dictatorship. What kind of procedures do you call it when the CLD can overrule the vote of the membership? The dictionary defines liaison as an instance or means of communications between bodies, groups, and units. Nowhere does it state that the liaison is a final authority, only a go-between. I emphasize again, no one should be granted that amount of power to micromanage and dictate to all the clubs in our community. There has to be a mechanism in place to ensure oversight by other members of the CA board. This in itself would hopefully stop the micromanagement and eventually ruination of our club system. All this chaos has been caused by a few individuals, less than 45, that are demanding special treatment.
Can you wrap up your comments here in the next
Yes, I
second?
can. What about the 11,000 members of our community that you are representing? Are you going to open up all our facilities to everyone in Hillsborough and surrounding areas? Don't forget you were voted to support the entire community, not just 40 individuals. Thank you.
Thanks. Thank you for comments. Mr. Messick, would you use the microphone and announce your name to him?
I thought I did. I'm sorry.
Okay.
Hi, I'm Larry Messick and just a concerned tennis player.
Okay. All right. Thank you.